This land law case, decided in the House of Lords in 1828, established the common law principle of accretion, although it did so based on ancient customs which existed well before the common law even commenced. So what on earth is accretion? Well, when land is bordered by the sea or by a waterway, the motion of the water will sometimes slowly and imperceptibly change the shape of the shore. Sometimes it digs into the shore and reduces the land, and sometimes it deposits mud and sediments and builds up the land. When it builds up the land little by little in increments too small to see, this is known as accretion. The next question then is, who owns that land? I mean, if you look at the original survey drawings on the title deed, that land is supposed to be underwater. But there it is. In Gifford against Yarborough, the land owned by Gifford had a border along the shoreline, and over time some 450 acres of land was added to the area by accretion. The Crown, which in England owns the ocean, claimed ownership of that land. However, so did Gifford. The House of Lords sided with Gifford. Because the land had been added to imperceptibly and over time, it belonged to the landowner. Chief Justice Best said, "We think there is a custom by which lands from which the sea is gradually and imperceptibly removed by the alluvion of soil becomes the property of the person to whose land it is attached, although it has been the fundus maris and as such the property of the king." Fundus maris is simply Latin for the bottom of the sea. The doctrine of accretion doesn't apply if the landowner deliberately encouraged accretion by using dams or dredging or something similar, and it also doesn't apply if there's a sudden weather event that exposes a large amount of land. The accretion has to be imperceptible. The doctrine of accretion is slightly more complicated in Australia because under some circumstances the sea and seabed are not owned by the Crown, but instead are held under native title. However, in general, the doctrine of accretion remains valid in Australian law.